Okay, it is 4 p.m. We will call the Committee on Public Safety to order. Please let the record reflect that all committee members are in attendance. If I could have a motion for the September 23rd minutes.
So moved.
All right. Proper motion has been made. All those in favor, please say aye.
Aye.
Motion passes. We are on to public comment. I would like to tell any folks who are in the room here that if you are here representing a property that is on our agenda today, you will have time to speak to that property when we reach that point in the agenda. Otherwise, you are eligible to make a public comment at this time. Are you here on a property, Sarah?
I'm not here on a property. I'm here on another matter.
Okay. Yeah, if you'd like to take a seat at the table and state your name.
Absolutely. So thank you so much for taking the time. My name is Douglas Mulkey, resident of 311 North Clements Avenue.
Can I get you to spell your last name? I'm sorry.
It's M-U-L-K-E-Y.
Thank you.
And I'm here today to make public comment on public safety of the 300 to 500 block of Clements Avenue between Michigan Avenue and Saginaw. Perennial issue of speeding has been a problem in the obviously everywhere. That's something that's very little to be controlled about how people are going to be driving behind their wheel. But I'm here to discuss something being done down that stretch. I live at 311 Clemens, and I've had numerous conversations with neighbors up and down the 300 to 500 block. Speeding down through there is out of control. We've got kids going to and from schools. We've got Lansing Catholics right there. There's another elementary school right near there. Over the last year, there's been property damage up and through there. Our EcoSport got totally crushed on the side. Constantly, people are flying through there. In particular, this what's prompted me to come here today and make note of this is on Saturday evening at about 12:45, there was a car flipped over in the middle of the intersection right in front of our house. People are flying down through there, causing accidents, causing property damage. Someone's going to get hurt through there. And essentially, that's what I'm here to discuss, to make note of it. On South Clemens, between Michigan Avenue and and Kalamazoo, they put in speed bumps through there. They seem to be working great. It's not necessarily my job to tell the council what would be, or perhaps whatever department's necessary to make note of this. But something's got to get done through there. And I just wanted to come here and voice my concern as a resident and the concern of the fellow residents and homeowners through there. So.
Thank you very much for that. You've already begun to solution some of the ideas that we do have available to us. Is your contact information on that sign in?
It is updated.
Okay, so I will follow up with you after this meeting and discuss in further detail what options exist and
Excellent.
about it.
I appreciate the prompt consideration of the matter, and thank you so much for your time today.
Thank you, sir. Any other public comment today? Okay, moving on, we're going to item 5B, a resolution to set a show cause hearing on orders to make safe or demolish 5210 South Washington Avenue. Do we have the property owner for the South Washington Avenue address present today?
I'm the personal representative for the estate.
And I just want to ask our city attorneys here, is it appropriate to have the representative for the estate here to speak on this matter?
I would defer over to our EDP department. I'm seeing on the sheet that it's not, who, are you related to the Schmidt estate then?
The Schmidt estate, exactly.
Okay.
So I'm personal representative for the Schmidt estate. I'm the second personal representative for the estate. Just learning of this action.
And there's a probate court order appointing you? Yes, it would be appropriate for him to speak on behalf of the estate in that.
I have the documentation if you need to see that also.
Thank you so much.
That would be helpful if you could submit that documentation just for our records to ensure that we do have the appropriate representative here speaking on
Sure.
this matter.
What is the best way? Would you like to see that?
You have my email address. If you want to email it. Yep, yeah. That way you don't have to hold up the meeting.
Sure.
And I'll get it out to the committee right afterwards.
That would be great. All right, so Director Van Fossen, would EDP like to speak on this matter first, and then we can move from there?
Sure, absolutely. Thank you. I'm also joined by our lead code officer, Tom Barry.
to plug in any details I might miss. But I'll just do a general overview, knowing that most information is in the packet. Trying to speak a little bit louder for Councilmember Hussein's sake. So apologize, Patrick, you're going to have to take the brunt of that. But this house was red tagged originally on June 25th of 2024 for a variety of reasons. A year later, the department made the decision to notify that we intended to hold a make safe or demolition hearing for the various reasons it was originally red tagged for and had not been since corrected or at least started to. That hearing was conducted on July 31st. I make one small edit to the cover sheet. It was a 30-day order issued by the hearing officer. Your cover sheet reads 60-day, but it does include the correct make safe date or demo of 9/2. The property on the next day, on 9/3, when we inspected, had no attempts to make it safe were made or attempts to demolish. Perhaps the representative here will shed some light into that. But you'll see by the pictures in our testimony that there are a variety of issues regarding the dwelling and including structural deficiencies. Unfortunately, somebody had deceased in this dwelling, and there are a variety of issues during that time which caused us originally to red tag it. And so now it has been referred to City Council for further consideration.
Okay, and the recommendation from your department is 30 days to make safe or demolish.
Correct.
Thank you. Sir, if you have any statements or comment to make on behalf of the estate?
I guess I have more questions than statements or comments. As I stated before, I am the second personal representative. This just came to my attention, receiving the email about 10 days ago that this property had been red tagged and was in such disrepair. Pictures did great explanation for me that way. I need to know more about the process as far as demolition. The cost attached to it, the timeline, is that the 30-day, 60-day timeline passed at this point? We're just starting. I was appointed on, August 15th to this estate. So a lot of this has happened prior to my appointment. We're not sure where we'll move forward with this at this point. So
You want me to field some of that?
If you.
Sure. At this point, the way the process goes is we hold an administrative hearing. The appointed hearing officer renders their decision. If it's not complied by that date, which was September 2nd, we're then required to refer to council. So at this point, council is going to decide today if they're going to schedule a public hearing or a show cause hearing before all of council. And then it'll come back to the committee, but ultimately it's up to city council to decide the final decision. And that final decision could be to make it safe or demolish by another certain date. So that time, the owner or whatever party representation, that'll be the final date to either make it safe or demolish it. If it's not achieved by that date, then the city receives jurisdictional control to come in and demolish the property. And that takes time to bid out and check our checklist. If we do that and we demolish it, that expense gets put on the tax roll as a debt owed to the city. Certainly, whatever interest is controlling the estate right now can act today and either start making it safe to remove the red tag and safe for occupancy or begin efforts to demolish it themselves. I certainly always encourage that because you'll find that that's likely going to be less costly than waiting for council to render a decision that ultimately might cause the department on my end to do the demolition.
Sure, understood that. Okay, very good. You said out for bid?
That we would only put it out for bid. I don't have the exact weeks, but today simply there's no decisions being made today, but perhaps scheduling a show cause hearing. That hearing will happen at the next.
So the show cause dates that would be set after today would be November 10th. And again, that would be in front of the full council. There is a portion in our meeting where certainly yourself as the personal representative may come and speak to the full council. At the podium, you would have 3 minutes for public comment. You can also submit comments in writing if you feel that your comments would go past that 3 minutes. We're happy to accept those comments in writing as well. And or any questions that you have prior to November 10th, when the potential date is for the show cause hearing to be set. As Director Van Fossen said, at that time, if the, you know, it's sent back to this committee, typically that takes 1 to 2 weeks. So, you know, this is paced out every 1 to 2, potentially 3 weeks for each step that we're looking at. So the future dates are not certain today, but the next date would be November 10th for a show cause hearing.
Thank you. That was one of the questions I had. If this was the determination date today, could we have an extension? Just,
This is the first day in which this is being heard at city council. So
Yeah, and so I wouldn't necessarily call it an extension, but there is a timeline, there is a process. So, you know, to say that this certainly isn't the final word, but it's the beginning of this process with council.
thank you. From the red tag standpoint, do you have a checklist of improvements that have to be done to remove the red tag? Could the estate get a copy of that? Is it something that?
I can give you my card. It won't be a checklist, but it'll be the original enforcement letter. Yes.
I have a copy of that, so I'd appreciate that. That'll help us determine
Sure.
moving forward.
Okay, and after this meeting, sir, you're welcome to
Yes.
speak with Director Van Fossen and follow up in more detail on what you may determine to
That'd
do
be
after
excellent.
today.
Thank you so much. I appreciate the information here.
Absolutely.
Any comments or questions from committee members on this property?
I have fun.
Okay. We have a motion to set show cause.
I would move to set a show cause hearing for 5210 South Washington.
And that date would be November 10th. All those in favor, please say aye.
Aye.
Okay, and that motion passes. Moving on to our next item C, the resolution to set a show cause hearing orders to make safe or demolish 906 Prospect Street. Do we have the property owner here?
Here on behalf of Freedom Mortgage Corporation, mortgage on the
Email me.
property. Thank you for your time.
May I take your name, please?
Brady Diller.
And I know there's also another circumstance here where you are not necessarily the property owner.
So,
Can you explain your presence here today?
yeah, we were told to be here by the clerk. We have a mortgage on the property and, we're aware of this and obviously to the legal extent that we can, given that we don't have title. We're trying to work with the owner to remedy these. We were just kind of briefed on this by the client today, so I don't have a ton to add.
Okay, so we're gonna move in the same fashion. Director Van Fossen will give an overview, and then if you have comments or questions, we'll follow up then.
Appreciate that. 906 Prospect. This was originally red tagged on August 2nd of 2024. You'll see in the photo evidence a variety of structural deficiencies presented at that time, significant roof decay, et cetera. The department did make a decision nearly a year later to hold a make safe or demo hearing on July 31st. The hearing officer at that evening issued a 30-day make safe or demolish order that put it at 9/2 of 25. We completed our inspection the day after. And again, no attempts to make the property safe or apply for demolition permits have been made. Our recommendation would match the hearing officers, which would be a 30-day make safe or demolish.
Thank you. And Mr. Diller, you did just hear the previous comments for the last property, sort of what our process would be. But do you have any comments to offer or any questions for us?
Yeah, I guess. So like I said, I got a little bit of a briefing today. It's my understanding this individual's living in a van on the property. Is that, I don't even know if that's correct or not.
No.
Okay. Or if
It's not recently.
Yeah, if they're even at the property at all. So, yeah, I was told that they're in the foreclosure process, but they haven't, obviously we don't have title yet, hasn't been completed. So obviously there's limitations to what we can do in terms of entrance onto the property. Yeah, that's all. I've been told he's delinquent, but they haven't finished that process. So obviously there's any sort of wiggle room we can get with some of these dates, just to, you know, work with the owner if we can. I'm not even sure
Sure.
what his status is, to be honest with you.
The only notes we have regarding the homeowner was that they are living in Florida and they stated she is abandoning the property and surrendering it to the bank.
Okay.
We do have a note of previous squatters, but they have since been removed from the dwelling.
Do you have any more dates information for that?
Of the dates in which they were
Yeah,
removed,
the whole, I didn't know there were squatters. They would obviously like to know about that.
we can look now if anything, I would ask that you shoot me an email and we can try to. get
Yeah,
it more.
yeah, happy to.
My only suggestion or ask of the committee, whether Brady, you're able to answer this today, is if the bank is in foreclosure proceedings and can offer a timeline, I'd be interested to know that timeline and to know then what the bank's plan would be if they get control, get title. Would that be to make it safe? Would that be to simply put it up for sale? Certainly, I think the pictures render that this is quite a safety issue on our end.
Yeah.
And so I defer to you all to make those final judgments, but those are questions we would deem appropriate to ask. Again, if that's within reasonable time, the department's open to that conversation. Certainly, if we're talking many months or years before anything, we would still ask for that 30-day recommendation.
And I would like to ask legal, a property that is going toward active foreclosure or just about at the threshold for foreclosure, any other type of recommendation that you would give to the committee in terms of moving forward, or does that not really have a bearing on the steps that we're taking today?
I would say that's a little bit outside of the lane of legal advice that I can offer this committee in terms of recommendations. You are within your legal authority to proceed with the make safe or demolish process as written, even if it's going through the foreclosure process, just the same way you do when properties are in the land bank process as well. So I would think of it similar to that, but as far as a recommendation, unfortunately, that's outside my lane and I can't offer one to you.
Okay, thank you. Questions or comments from committee members? Please, Councilman Cost.
Yeah, I think we continue to move forward the 30-day. I think as we've learned with many of these demos, things take time. So there will be time beyond the time we're allotted. By the time there's, all the stuff done, the demo contractors picked out,
I
could
agree.
be 6 months to a year, depending. So I would be fine. I think there's plenty of time beyond the 30 days that we give. On top of, all of the processes and everything else. So it's really more 60 days.
Sure. So as we do have the recommendation here for the 30-day make safe or demolish recommendation, do we have a motion on the resolution?
I would move it.
Okay, a proper motion has been made. All those in favor say aye.
Aye.
Okay, so this will be set for a show cause hearing on November 10th. If you would like to attend that meeting or make a comment at that time, you would. On any detailed steps you would need to take.
Yeah, a few more questions on that. Some of the facts you had, when they said they abandoned the property.
Not in my summary notes.
Yeah, I'll reach out.
If you each out, then I'll check the
Yeah.
in file notes to see if we have any of that information.
Yeah, that'd be good. Thank you.
Okay, moving on to item D, a resolution. Yes.
If you want to stop at the front desk with Renee, these meetings are put on our YouTube channel. She can give you the link to that so that you can share it with everybody and kind of rewatch this.
Okay.
If that way it might be clearer and you can catch some names and stuff like that.
Also, if I have to appear again in 30 days, does it have to be in person?
So we do have virtual comment available, and you can certainly submit any comments or questions that you have in writing as well.
Sounds good. I'll reach out to you later.
Appreciate it.
Moving on to item D, a resolution to set a show cause hearing orders to make safe or demolish 6 Marywood Avenue. Do we have anyone representing Marywood Avenue in this meeting? No? Okay. Raleigh, could you?
Sure. You got it. 6255 Marywood was red tagged on July 7th of 2022. There is significant fire damage as a result to our call out. See some somewhat recent photos provided in your packet. Not much has changed. We did conduct a hearing on July 31st. A 30-day make safe or demo ruling was issued by the hearing officer that evening, put it at September 2nd. Again, like the other two, no action to either remedy to make it safe or to begin efforts to tear down were noticed that day after, which is what brought us here today. This one will slightly differ in our recommendation because it is fire damage. So we would be recommending a 21-day make safe or demolition order.
Okay, thank you. Any questions from committee members, or do we have a motion for a show cause hearing?
Just a brief question. That first page, Raleigh, says 60 days on these. Is it 30 or is it 60?
30. There was a fifth, Beulah Street that night. That was a 60-day.
Yeah.
And so I think clerk, when she was filling out these forms,
I was there. I was like, I don't remember.
Yeah.
60.
These are all 30 today. Yeah.
Perfect. I would move 21 days for a show cause hearing.
Okay, all those in favor, please say aye.
Aye.
Okay. Motion passes. Next item E, the resolution to set a show cause hearing, orders for make safe or demolish 509 Baker Street. I don't believe there is anyone in the room representing Baker Street. Raleigh, if you can go ahead with an overview.
Sure. Similar fashion in terms of timeline, but this one was red tagged in June of 23 for a handful of reasons. Some structural, electrical, mechanical, water and smoke issues. This was a fire damage that began in the living room and extended upstairs to the second floor. Lots of, or what we noticed were a lot of the low bearing beams in the basement that presented some concerns for partial collapse of the floor. If not, there had been some partial collapse. We did make the decision to file for a hearing on July 31st. The hearing officer rendered a 30-day, which was 9/2. Again, the day after upon our inspection, no permits, no work to begin demolition efforts. We have not received any contact from the owner. We do have concerns, not as it relates to the MSD, but there are squatters. But we've had issues with them at this property in the past. This is another fire damage where we'd be asking for a 21-day make safe or demo order.
Okay, questions or comments or a motion to set the show cause hearing on the 21-day make safe or demolish order?
I'd make the motion, set the show cause here.
Okay, all those in favor say aye.
Aye.
Motion passes. Okay,
Can I just make a general comment on make safe or demo before we move on?
sure.
Hopefully committee will see and notice we're starting to get into a groove. We'll be scheduling, as Tom mentioned to me, right when our next group, we have about another dozen properties. We just got title work back today. I'm feeling a lot better than we were a couple months ago as staff are transitioning into these roles. As we're starting to get back, well, we don't have to have a hearing on a predetermined date, but we all agree and know that there are a handful more to be addressing. And so hope is you'll start to see more from the department as these staff continue. Yeah, please.
Since you brought it up.
Sure.
I just got a text today about that Caddy house. Is that going to be, because I believe we discussed that it was going to be on the next round.
2004.
Yeah, it is gonna be on the next round. Do we have any idea when you're looking at that meeting?
Not yet. So with title work back today, we now can legally do our notices. We have to give at least 11 days.
Probably beginning of next month.
I should know by either the end of this week or the start of next week when the hearing officers confirm.
If you
What
could just let me
specific
know.
house number on Caddy?
It was 1004.
Correct. Yep.
CADY.
Yes. Otherwise, we have 3 bids out right now for demos. Metro Bowl's underway right now. We completed Martin Street and Shepherd. So again, I know things have taken more time than I would have liked and certainly others, but I do see the team getting into their groove now.
Kind of hear you. Can you give us an update? If you did, I apologize. On 108 South MLK. Where are we at with that?
Sure. At this point, the property is ready to bid out for demolition. But my understanding, you have colleagues who I believe will be introducing a resolution to perhaps change that order. and I believe that's coming soon. I don't want to speak for those members, but at this point, we've completed our testing just about 2-3 weeks ago, and now I can put it out to bid. My understanding is if a resolution gets introduced, the department will stop any effort until that decision has been answered.
Okay, Lisa, I've got questions now. Once we give a 30-day order, they have 20 days to appeal it to a circuit court per state law. So if they don't appeal it to the circuit court, the matter is done. So how can we reconsider something?
My understanding that on that specific property, there was new information by the property owner presented to council members that have led them to potentially reconsider the decision. And so a resolution may be forthcoming. Is that fair?
I can speak to this if you'd like. I'm happy to speak on it. And hadn't yet because there was nothing solidified to present or necessarily discuss. I had received an inquiry from one of our colleagues as well on the property. Through all of these weeks that have passed by, the property owner continues to submit information to myself that I have passed along. But of course, not understanding that there is a process that EDP is going through at the same time. So everything from additional streams of revenue have been submitted to, I'm sorry, it was revenue, a timetable for further work, the property owner committing to pull permits and put more of their personal money into the property to continue the work. So I today can't say that it necessarily meets the threshold for me personally on whether or not I would resolution, but there is interest from at least one other colleague of ours who may be interested in doing so. That being said, receiving information, passing it along doesn't necessarily stop EDP's timetable on what they have to do, putting out the bid for contract and taking their additional steps. And so if there was a draft resolution has been reviewed, but I will say on my own behalf, I have not made a determination on any next steps for that resolution. And so that is where we are today.
It's interesting that leadership doesn't know anything about this. And the other curiosity I have is if we revisit this property because they suddenly have money, we're going to have to revisit every one of these houses that we have put our foot down about. And I still do not understand, Lisa, where we make a final determination and they have 20 days to appeal it to a circuit court. And once they don't do that, they're done. How can we reconsider something that's done, that's gone through the process, that has an appeals process through circuit court? Because if we give her another chance, then hell, we may as well stop doing this because it's a dog and pony show. I mean, these are orders by state law, correct?
They're orders made pursuant to state law. That's correct.
Okay, so I'm not understanding where we're finding all this wiggle room. And they found money here, or they're going to do this. She's had the house for 4 years and didn't do anything with it. I have sympathy that that is a historic house, but I also understand that they've been holding on to it for 4 years. And when did we make safer demolish it? When did we make safer demolish it? I mean,
I think
it's
April or May of this year.
it's getting a little
I think there is
ridiculous.
some question. There are some questions with regard to legal. I think in the comment, but I agree completely. I think the ED&P. I think you have to proceed fairly and with fidelity. So I'm shocked to hear that there might be a little bit of pausing or pumping on the brakes because some council member has some harebrained idea that they're going to pass or bring forth a resolution that then throws into question everything we do on council. I'm getting a little tired of people playing politics, frankly, at the dais and with resolutions. This particular applicant had a very protracted opportunity to do everything that everybody else has had an opportunity to do, and they failed to do it at every turn. And it feels like there is, whether it be from council members, whether it be, with all due respect, economic development and planning, it feels like there's a little bit of privilege being extended to this particular person. And if I was somebody that had been through this process and I had lost, as an example, my property, I'd be madder than hell and I'd be suing the hell out of the city if this thing is approved. So folks need to get their act together. With all due respect, I would hope that legal would, and this is more for Greg, would make sure that they're advising council members in that manner. This is a slippery slope I don't think you want to go down, frankly. I don't know who the council member is that got this idea, but somebody needs to, maybe leadership needs to have a conversation with, I don't know. But that's not good. It's not good.
No.
Yeah, so I'll just make some comments on that as well.
Yeah.
I don't disagree with you.
And I'm not trying to be a jerk, but I'm
No,
right.
I
Yeah.
understand.
Okay.
I understand that would be a slippery slope.
Very.
And I understand the ramifications
Yep.
that potentially it could cause. Which is why a variety of council members were invited to look at the property, have conversations. To me, that's not a determination of.
So are you bringing the resolution?
I'm sorry, can I
Who's
interrupt?
bringing the resolution?
We are getting a little bit into deliberation on a specific property, on a specific matter that is not on your agenda.
Well, it sounds like that's all been happening anyways, which is interesting. Sounds like council members have been talking about it. They've been meeting out on the property. Sounds like it's already happened.
Well, I think any one of us are
Deli-
able to have.
No, but it sounds like more than one council member has been talking about bringing a resolution forward. So that's problematic. If we can't talk about it in this meeting,
No, I'm not saying you can't talk
Right.
about it in this meeting, but it needs to be properly noticed on the agenda to really get into the meat and potatoes of deliberation of the,
Okay.
is all that I'm saying.
Okay.
I'm just giving you.
and if I'm speaking loud, I apologize. I'm not trying to, with extra emphasis. I can barely hear myself, but I am just blown away. I've been on this council for 10 years. I've never, ever seen that happen in that way, or a conversation like that be had. And it's,
I mean, and you asked the question, who is this that's bringing this forward? Because leadership is unaware.
or it should have been brought up. If we can't know, it shouldn't have been brought up in this meeting. ED&P, until
We
there's
should
a
at least have
resolution in
an
front of the
idea
body,
who-
should be
who.
proceeding like they proceed on every property. Then to make sure that this city is not positioned to be litigated against successfully over and over and over and over.
I'm not comfortable sharing that.
And it should have been brought up. With all due respect, Raleigh, you all should be I'm not your boss. You all should be proceeding as if there is no resolution coming. Because right now, we don't have a resolution to discuss, to deliberate on, et cetera. Period.
I'll add further comment to that without
Go ahead.
trying to not do what you asked us not to do. I don't believe that EDP has caused their efforts to this point, specifically for that property. I believe Director Van Fossen said if a resolution was received or was on an agenda at that point, their work would pause. I believe that's what I just heard. And I will offer.
Okay.
I will offer this information. I had a conversation with the property owner, took the property owner up on the invitation to view the property, which I did. She continued to submit information to me, which then I did pass along, understanding that this may not meet the threshold. This may not be enough. Thank you for, continually, submitting this additional information. And that's essentially where we are today. I asked questions of legal to understand, if in fact there was specific information unique to a property, because I understand the liability and I understand it's a slippery slope. Is that something that could be pursued? And so that is a conversation that I did have with legal. I didn't have anything that was materialized enough for me personally to come to leadership and say, this is something I would like to pursue through council. So as far as leadership awareness, I can say that if I come to you with something that is materialized and I have confidence in, I thought that's the point in time where I would bring something to your attention or ask for an item to be placed on an agenda, but
And maybe I
to
misheard
this
you.
date, I have not received enough information personally to confidently say, Council President and Vice President, this is my request.
And
or-
and maybe I misheard you a moment ago when you said that something had been written and vetted by legal.
So I asked the question if there was specific information to, well, we're talking about this property, so I'm sorry if I'm veering into territory that's not on the agenda. And so a draft was provided to me.
So there is a
However,
draft, so are we pausing it?
No, the draft had not been sent
Not seeing.
any further than to me to review language. But again, seeing what was in there, the language that was in a draft didn't necessarily speak to the information that had been received from the property owner. And so again, a draft is not a final product. The information that has been received hasn't necessarily met that threshold. There was nothing solid to move forward on as of this date.
Thank you.
And that all makes sense, and I apologize. But Raleigh, the implication, right, at least from what I heard, right, is you said that it's ready to go out to bid, but, right? And so as if departmentally, that has caused you some pause because there's this conversation about this potential resolution that may or may not come down the pipe. And so I guess my ask is, and again, an ask, I can't direct, but we have directed, right? I mean, per our resolution and our decree, we have directed. I would ask that you all proceed to the path.
We agree.
Oh, okay. Take the head nod.
Yeah. And for clarification, I will say Director Van Vossen, as I've submitted information, sent it forward, continually saying, this isn't necessarily what EDP needs to see. So my assumption is that everything was moving forward. Information was sent forward, but the process was still continuing throughout this entire time. No,
I heard you enough.
I understand. No, I understand. And I would say in this meeting to President Cost, if there is a different way that leadership should be informed of activities or information gathering or ideas, I would like to understand that better, I suppose. If there's something that isn't quite materialized or ready to present, but for awareness, there should be more of a conversation, a direct conversation between council members and leadership. Please let me know because I'll, make sure to do that.
Well, and I was shouting because he can't hear crap. It became quite confusing when we heard what was said here and then that there was a possibility of something written. And so this whole thing got very confusing very quickly and off topic. I understand that. I think what the confusion lies around is the process, right? I'm still getting calls about 3134 Viking that we made safe or demolished 6 months ago, and it's still standing. And we can't understand why the owner was in our office last week asking me to do something about it. And this is the kind of, if we go down this road, that's going to happen more and more, where everybody thinks, oh, you know what? I'm going to drag my feet. I'm not going to really do anything. They'll just keep giving me more time. And that's the hole we were in. Raleigh knows this before he came on board with the MSD board,
And the
where people
consistent
were
tabling.
it for over a year and a half. And now we're sitting in the same thing where, why is a house up? I mean, we had to fight like hell to get that house that was half knocked down. Took us a year to get it knocked down. So I guess, and I talked to Greg about this earlier, Lisa, is some clarification on, this process and can we actually go back on this thing because it does have the piece that I shared with him where someone has 20 days to appeal it to a circuit court. So if they don't appeal it to a circuit court, I would imagine that that is the final, that's it. But it sounds like there is a legal option to revisit and retake up this issue at a later date and reverse course.
I mean, at this point, I would invite you to speak with Mr. Venker about it.
I do have a suggestion for our process as a committee, if this is helpful. I don't know that property owners are necessarily aware of the appellate process after our order is final. I don't know that it's natural for them to think, now I need to appeal to circuit court. So if we can provide that information after a final order is voted on, I think that could be helpful to bring awareness to all property owners that are within this process, at least for those final steps. Okay, are we comfortable moving on? Okay, item 5F, a resolution to introduce and set a public hearing on the zoning amendment 1240.04, the definition of a liquor store. Andy's probably.
We have, yep, I'm here as well as we have Andy from
Okay.
the department.
Great.
I just know that Andy wrote the memo, so.
You'd like
I
to
think
speak
you're
on
covered.
this? Thank you.
Yeah, so we introduced this at, when we got it, we introduced it to planning commission at the September meeting. But when it came to us, we didn't have enough time, sorry.
No, you're fine.
We didn't have enough time to set a public hearing. We didn't have enough notice time for that. So that's why it was scheduled for October 7th. We conducted that public hearing meeting at planning commission. One email was received and it was added to your packet, and no one from the public was there to comment. So the commission members talked amongst themselves. We outlined some other consideration of zoning changes that they might be able to consider to make a recommendation. But as discussion unfolded, they mostly just were supportive of council's efforts and the draft that you forwarded to them. There were some clarifying questions. I added that to the minutes. But in general, it was just to support the work that council has done.
I did see there was also a letter of support for this included in the package as well
Yes.
from a member of the public. Any questions or comments from committee members or Director Van Johnson, any input?
The only additional input, I know he just briefly told it, and I told him earlier today I might bring it up, but I just want for education standpoint for the three members and certainly for your other colleagues, when we looked at it, you're the legislative body, get to draft and pass ordinances. We understand that. At times you can work with the administration, you don't have to. This was a case where we received after fact. So I would want you to pay attention and see it's on the bottom of the minutes, first page going in the second. Those are the 3 or 4 suggestions Andy and Sue proposed to the planning commission to add even more teeth to this. As Andy mentioned, planning commission didn't take us up on that. Certainly you're welcome to, but we tried to take what we saw as the intent behind the original draft and provide a little bit more to it from our effort that could perhaps make this even more robust. But that certainly is for your consideration. And Andy would be able to more eloquently speak on any of those, but wanted to make sure we pointed it out.
Is there any desire from committee members to entertain some of these 4 suggestions that are listed in the document, or proceeding as is with the draft that we have been working with?
Have these been vetted by law?
No, not at this time.
If I may, we didn't make any specific suggestions. We just had the broad overview of what topics could be considered.
I don't know that we have any more drive-through liquor stores.
What's that?
I don't think we have any more drive-through liquor stores. That was one of the suggestions. I mean, we could always send this, move it forward and ask law to take a look at these 4 bullet points that they have in here as well.
We certainly could.
I think there's good points in here, additional distance from schools, childcare centers, parks, worship. Yeah,
So then the next step would be to send this to law to review, to add or redraft. I'm sorry, what was your suggestion? Or to move forward with legal considering those additions?
I think we can move forward with legal considering those additional things.
Okay.
They don't appear to be big changes, and it looks like they probably could get through that pretty quickly.
Okay, and I don't believe it changes the substantive nature of what the.
These are
I guess
add-ons.
Accomplish.
The question is, are you looking for law to make changes to the ordinance?
To add these items into this.
Okay, well, that, I mean, that may,
That would be
That
substantive.
would-
I think the question, I guess I thought you were asking them to vet these and determine whether or not these would comport with statutory framework and.
I mean, we can always ask them to vet it and just table this.
That's probably the smarter thing to do.
May as well get it right the first time.
Okay, so, no, please go. Do you have a comment?
No, I just looked at her expression.
I would just like to point out that I ran into the state senator. They should be introducing their portion of this issue anytime this week,
Oh, good.
either this week or next week. So I had the pleasure of meeting, running into him at the hockey game.
Oh,
He sat right in front of me, so there was plenty of chatter.
and I know we're on item F, but would,
You want to table a motion to table
yes.
with the directive of,
Yes,
OCA
so
looking at
we'll
those.
look for a motion to table with OCA reviewing the 4 suggestions under item 4A to vet and potentially include in a new draft of.
yeah, I guess law would need to know, are you looking for us to include all of these? If we can, we need a little bit of direction on what the committee is asking us to draft.
So what I'm hearing from committee members is we would like to include the 4 items that have been suggested, if in your opinion, it's appropriate to do so, if it meets the standards and if there is a way to have them included within the ordinance.
Thank you for the clarification.
And if there is any one of these 4 items that you don't believe should or doesn't meet some sort of legal standard to be placed in there, we would like to know that as well.
Can do.
Okay, and so I'd like a motion to table this item. Would our next meeting be enough time, or would you need additional time? And I'm sorry, you have
No,
a
no, no, go ahead.
question.
I'm going to give you the classic legal answer here, that it depends. If you're looking for language added on all 4 of these, to add that language and get through ordinance review committee, I don't know that it could be done in 2 weeks. We can certainly aim to do that as quickly as possible. I cannot make this though, or I don't want to. If I
But we could at least have it on the agenda as a discussion item to see where we're at. I guess what I was, and again, I apologize, but I'm trying to think from your perspective, how difficult it would be to look at this and then figure out, what's going to be proposed. Would it be appropriate? And I mean, I would assume because you brought this to the planning commission, that you have some ideas. As an example, for the 4th bullet point, but would it be appropriate if he chimed in with you guys and talked a little bit about.
I don't want to set policy for you.
No, I understand that, but working with the administration, right? If there are some things that make sense, that might be at least a starting point. I mean, I'd be fine with that. You know what I mean? So that we can then, as a legislative body, consider.
I think if the question is asked, if I'm hearing right from the committee, which I think I am, that as legal and researches this, if from our perspective as well, can provide framework that if legal can confirm, yes, additional architectural standards could be made, we can help draft some of what that may be for the committee and council to consider.
Yeah.
Okay. All right, so as to any more questions or points of clarification before we move forward? Okay, so as to item F, we'll take that motion first to table places a discussion item at our next meeting.
So moved.
Okay, all those in favor say aye.
Aye.
And moving on to item G, there were similar suggestions within this document at the end of the page 2, going on to page 3. Actually, they're marked as page 102 and 103 on these documents at the bottom. So it looks like the same suggestions were brought up. And so as these are companions, are we comfortable tabling item G as well and bringing back as a discussion item at our next meeting?
So moved.
Okay, all those in favor say aye.
Aye.
Thank you. Okay, on to our last item of business on the agenda, item H. We have a report from ED&P Code Compliance on corridor enforcement. This is a lengthy list. It looks to be the entire year.
Yeah, so we made some assumptions and we went trying to query this report ourselves. We continue to learn with the new version of BSNA things we could do in the past that we can't do today. And running this report was unfortunately not an item between, and I tasked 3 divisions with this: code, building safety, and zoning. And so we ultimately had to reach out to BSNA for that level of support. This is a version we got back. So this includes, since January 1 of this calendar year, all enforcements across those 3 divisions for any commercial property. And so it's capturing everything in the corridor with any exception of the few residential parcels that might be on a corner street. And then it's also inclusive of commercial properties that might not be on an immediately defined corridor. But there wasn't a way in the system for us to just do corridors, if that makes sense. BSNA doesn't, the word corridor doesn't work in BSNA's language, nor can I set a radius. And so what we opted for was just take commercial, which is a property classification code they can use as a tag when running a report. So out of that, I think there's 820 or so enforcements that we've taken on all commercial properties. My hope is this will give you something to start with, but absolutely we're open to feedback to further refine this as you see fit.
Thank you. Please, President Cost.
Raleigh, what are we doing? I see a ton of send letters that are aging to about a year now. Are we going through and trying to clear out some of these older ones?
Yes, so send letters, or could be a variety of things that this report wouldn't show. It could be if an extension was offered by the officer, that extension won't show up. I will say though, a majority perhaps could be pending court action. That's also not something that we're showing up right now. We're working with BSNA to add that as a field so that they'll send letter and then it's going to go to a court order compliance ticket. We're looking for BSNA for us to record that so that I can run you another report that'll show you that. Any though that have not been written a ticket, it's likely just because of either new folks coming on board and having recently been trained. So it's going to be a combination of those, but also learning what BSNA can show us in a report.
And I'm assuming there's things on here like 1421 East Kalamazoo Street that are send letter. I don't think there's any red tags there, is there?
I have to look
That's monopoly.
it up if there's an actual red tag. This report doesn't indicate if it's been tagged or not. It could be, unless Tom will.
Well, yeah, I can do that. Just
What was the address again? Are you on page 2?
Yeah, it was 1421 East Kalamazoo Street, safety. I think that they've cleared up all of their stuff.
If they cleared it up and it's still on this list, I'm just trying to find it on page 2. How far down are you?
3/4 of the way.
3, say that again, Tom?
This is the code enforcement number 641.
Yes, that's the open one.
Yeah.
The one before it was complied. So we have an open safety letter.
Yeah, there's actually like 3 safety letters.
Okay.
So This is an apartment complex. So somebody could have called us up to do a safety inspection.
Okay. All right, just, I mean, I'm just curious, because it sounds like the send letter, it's a lot more complicated than just send letter.
A send letter will tell you if that means the issue is still open on our end, if it's a send letter.
Also, the what can get confusing when you look, because I fell into this as well. You'd have to match up. It might say send letter, then there might be a failure to comply, then there might be a pink tag or a red tag. Unfortunately, the list, it's hard to get that to follow through. I tried to ask BSNA to do that so I can keep everything together. Fortunately, they said there's not a way for them to tie those knots together. So you literally have to open it up and follow through in the system itself.
Gotcha. I appreciate the answers on that.
May I ask what the difference is between complied and resolved?
Resolved would be our contractor going in and abating the situation, whether it's grass or trash,
Okay,
and it's marked as resolved.
okay,
Complied would mean that they did it on their own, and
okay, thank you. This is a lot to digest. It's a lengthy report. Is there any desire to leave this as a discussion item for our next meeting? If we would like time to review and maybe come with follow-up questions?
Sounds good.
Okay, we'll place this as a discussion item for our next. On the agenda, we are adjourned at 4:56 p.m.
it's not failure.